intervene. Yeah, I'm very worried that this thing now isn't recorded. That's all right, I'm doing another one on Thursday. I might just do it to myself at home. That he rushed to the Constitutional Court and said, we have a duty in this state to ensure that corruption is addressed. So this Constitutional Court needs to declare that the legislature has not complied with a constitutional obligation of passing a law that is going to give effect to our international obligations to prevent corruption, and with the Constitution itself, which says that we're a state premised on the rule of law and protection of the rights of all. If there's corruption, then those rights are going to be denied. And the mistake that Hugh Glenister made is that by rushing to the court then, the court said to him, you need to respect the separation of powers. And that's when they used this concept of the separation of powers being axiomatic, meaning? Implied, yes. We know it's there, but we can't see it in writing anywhere in the Constitution. We just have to believe that it exists because of the way that our Constitution is constructed. Even though, as I've said, nowhere in the Constitution does it explicitly say we shall have a separation of powers where the legislature does this, the judiciary does that, the executive does that. So that it is a separation of powers, but it's being developed. But in any event, the court said, it's not our role to tell the legislature how to do its job. So because this law is still in bill form, so the amendments were still only a bill, it wasn't finalized yet, the court said, we cannot tell them what to do. You need to come back to us only once the law has actually become operative. So that's where the judiciary does respect the role of the judiciary. It understands the limits of its powers, and it respects the institutional function of the legislature. It says leave it to the legislature to do that. So then in the successive cases, when by this time the legislature had finalized the process of amending the National Prosecuting Authority Act and the National Police Services Act, finalized it, and then Hugh Glenister went back to the Constitutional Court and said, can you now agree with me that this amendment is fatal to the proper functioning of our state, because now in order for corrupt persons to be investigated, you first need to get permission from the police commissioner, and therefore the police commissioner is going to say, no, you can't investigate this ANC person or that UDM person. So that's when Hugh Glenister went to court and said, can you make an order that Parliament changes the law so that we can be assured that there will not be any form of interference or corruption that's possible because of too much executive pressure or power over the functioning of the hawks. And there too, what the court did, the court doesn't then say to the legislature, you must do it in this particular way and it must say X, Y, Z. They'll say to the to the legislature, here are the problems, so they'll set out what the problems are with the law, and they'll say, but it's your prerogative to decide how best that new law must be formulated. And so to bring us to your earlier points about, and the ANC have been known to say this of late, where they say these opposition political parties are trying to govern through the courts because they don't have the democratic majority, so they keep running to the courts to have their way. And it does give the impression that the judiciary has got too much power, and that's why opposition political parties might be using them to govern indirectly. And that is your classic counter-majoritarian dilemma, where the majority is the 400 people sitting in Parliament who we have elected to be there, We've empowered them to make the decisions about what the law will say. Very importantly, we empowered them to vote on our behalf, to choose the president. The president then is empowered indirectly through them to appoint the ministers, so his cabinet, and appointing the deputy ministers. So all of that is in terms of what the majority will wants, and then along comes one judge, and he has the power to say, sorry, the law passed by all 400 is invalid. That's when it looks as though one person is more powerful than 400. So it looks, it's the counter-majoritarian dilemma, because it is the inverse of how you think it would work. In a real democracy, surely the majority say should prevail. And yes, it does. But when the court, acting impartially and independently, looks at the factual scenario juxtaposed against what the law says they must do and what the position should be, and if they say there's a say that word again. Yeah, no, it's another word. What's the one that we use when incompatible? That's the one. Sorry, incompatible. Relationship, yes, that's it. I like that. That is incompatible relationship with what the law says. Sorry, you have to change the law. Even though I'm only one judge, I am not acting with malice or just to stymie the political processes. I'm only doing this to uphold the Constitution. And that's what Section 172 says. It says unambiguously, the judiciary must declare any law or any conduct invalid to the extent of its inconsistency, so that corrective remedial measures can be taken, and that the law can be amended, or that the president can be removed. So you're happy then that in fact the counter-majoritarian dilemma is not a dilemma, and in fact it is essentially the will of the people, because our Constitution says that that is how the system should work, where the court can have the final say about whether law or conduct is unconstitutional. And that then brings me to the three cases in your tutorial letter 102 that I think will also elaborate on this issue of how do we know that the president is really going to act in the best interest of the country, and how can he be held accountable. So Section 1D of the Constitution. So 1C, you know, it says that we are a country premised on the rule of law. 1D emphasizes that we are a state where accountability, openness, responsiveness are the bedrock of our entire constitutional system. And therefore, when understanding the principal functions of the three main organs of state, you must realize that all three of them actually are accountable. How are the judiciary accountable? They are accountable because they publish their decisions, and that's what I'm making you read. And you can criticize it and say, the court has made a fundamental mistake. You're allowed to do that. You're allowed to write a newspaper article saying, I don't think the court construed the law correctly. And the court, therefore, because they know that their decisions are written and are then in the public domain, they are more cautious in the decisions that they make. And that's why for every argument that has been put to them, they will justify why they agree with that argument or not. And that's why, and this version doesn't have footnotes, but the electronic one does, where you'll see how the court says, this court has previously said that the president must be removed from office if he is found to have seriously violated the law, for example. They justify why they're saying what they're doing, and likewise, the legislature must justify why it's doing what it's doing, and the executive must be able to explain and account for how it is implementing the law. So let's start then with the legislature. It's 400 people representing us. Section 95 of the Constitution says, and this is clear from the EFF cases. So the EFF cases emanate from the public protector, Tuli Madonsela's decisions in the report called Secure in Comfort, where Tuli Madonsela had been asked to investigate. She'd received a number of complaints. So she was asked to investigate whether the upgrades at Jacob Zuma's Nkandla residence were genuinely security related, or whether some of them were not security, and therefore that he had unduly been enriched or benefited by the state, the people of the state paying their taxes, and that therefore he should pay back a portion of that money, the amount by which he was unjustifiably enriched. And that report, and that's why the Constitution says that in Section 182 the public protector can investigate, she can draft a report, her report must have recommendations, she then has to give that report to the National Assembly, so that the National Assembly can look at the report and take decisive action in terms of it. What happened, unfortunately, even though Section 95 of the Constitution says the National Assembly has the powers to regulate its own affairs and to formulate its own procedures and processes to decide how best to function in terms of our constitutional democracy, Section 97 then says special mechanisms should be created so that we can be assured that the National Prosecuting Authority can hold the executive to account. And what the National Assembly did when they received the report saying that Jacob Zuma had now been unduly enriched, it was again one of those scenarios where they didn't really know what to do with it. They don't really want to have to say to the president, pay back the money. So they sent the report off to an ad hoc committee, headed by the Minister of Police, because he's in charge of security, so let him decide if these upgrades are really security related or not. And that little committee met and they deliberated, and their report back to the National Assembly was there was absolutely no evidence that Jacob Zuma was unduly enriched. So then the EFF and the DA and the UDM kept saying, we're not happy. This is not good enough. As far as we are concerned, it is clear that he has violated the law because he's unduly enriched. He has benefited for no justifiable reason. Please, can this matter be dealt with effectively? So then another ad hoc committee got to look at the report and deliberate. Again, they exonerated the president. And as you will have seen, the State of the Nation address in 2015 was disrupted because the EFF stood up and said, pay back the money. Which, of course, is actually the very same phrase in our current, with the latest Corruption Watch Nkasana matter. He also had to pay back the money. So it's clear that there is now becoming this determined effort to make sure that if money has been appropriated by unlawful means, it must be paid back. So the point of the EFF case, in the first instance, was, so there's EFF 1, EFF 2, and UDM, and the three are very much interrelated. But the first EFF case was a case where the EFF said to the court, they said, please find that we are justified in arguing that the National Prosecuting Authority is actually violating the Constitution by ignoring the recommendations of the Public Protector. So their first focus in that case was, what is the role of the Public Protector? So therefore it is that case that has confirmed for us that there is no longer any doubt about the status of the findings of the Public Protector. They are binding and must be implemented in good faith as soon as possible. So that was the one part of the EFF case. And of course it was a magnificent victory for constitutional democracy. But even though the EFF was successful in that regard, they still weren't actually satisfied with the democratic processes in place in the state, and they therefore went to court again, and that's hence EFF 2, and they said to the Constitutional Court, what we need from this court is an order that the National Assembly has failed to comply with the Constitution because it has never actually acted in terms of Section 97 of the Constitution to create special and effective mechanisms to hold the President accountable. They said in all these votes of no confidence that have been happening, because the first one started with Mazibuko versus the Speaker of the National Assembly. That was when Lindiwe Mazibuko was head of the DA in Parliament. And what the DA did is they went to the Speaker and they said to the Speaker, please can you put on the paper for what is to be debated in Parliament at the next sitting, that we want a vote of no confidence in the President. And the Speaker said, no, I'm not doing that. You can't tell me to do that. I don't have to do it. Do you see, she was colonized. Well, in fact, at that stage, it was not Baleka Mbete, but she became more and more determined to protect Jacob Zuma as time went on. So you'll see that there was this process where the EFF realized this Parliament is never going to hold the President accountable because they're not doing enough to actually ensure that there's a proper procedure in place for a vote to legitimately take place. So that's why the EFF went to court saying, we need this court to actually, and this is the interesting part about that judgment, make an order that Parliament has failed to comply with a constitutional obligation imposed upon it to make these effective mechanisms. And in the decision of the EFF2, I've only given you the parts you really need to know because otherwise it's very long, but you will see that there was a majority decision by Chris Jafta, and there were a couple of minority and dissenting decisions. And one of those, and I've included it as a little sentence in the commentary, is where Chief Justice Mogoeng said, he was, and it was widely documented, he said, this case, or the decision of the majority of this court in this case, is a travesty of justice. It's a textbook case of judicial overreach. He was trying to say it's not our place as the judiciary to tell the legislature how to do its job. But the majority in the court said, we don't agree with you, Chief Justice. What we are doing here is we're merely telling Parliament that they must now formulate proper committees who will be able first to actually decide whether or not there has been a serious violation of the law or a serious violation of the Constitution by the President. And then once that committee has done that, then they can put it on the roll for the rest of the Parliament to vote on it. But at the moment, we're not having any processes, and that's why the entire system is flawed. So that's what the majority said. So even though Chief Justice Mogoeng disagreed, and he said we've gone too far, what the majority did is actually, to my mind, consistent with the constitutional democracy, because they were making sure that the President can be held accountable. Because unfortunately what we saw was it eight votes of no confidence, and none of them, well, President Zuma succeeded in all of them, but even if, and this is what's important about EFF 2, the court said even if the vote had proven, or the vote had resolved that the president should be removed, he actually wouldn't have been able to be removed, because that preceding or antecedent committee decision saying that we are clear that the president has in fact violated the constitution had not been made. And that's why now it's a two-stage process, that Parliament have to now formulate those committees, and whenever there are any future allegations that the president has seriously violated the law or has violated the constitution or is unable to continue functioning as president, that committee must decide whether that's true, and only then can it be put to a vote. So that's why the EFF 2 case has now, it's really helped to strengthen the independence of the National Assembly, because there are now strict procedures in place, and the majority cannot, or their vote cannot outweigh the factual, objective determination of whether there has been a serious violation of the law or a serious violation of the Constitution. And why that case is also so relevant is because it articulates all the incidents where the president had violated the Constitution and violated the law. And I'm emphasizing this because this weekend, President Zuma again said, "But I've never done anything wrong." And while he might genuinely believe it, there's court records, there are binding decisions in the public domain proving that he did violate the law. And that's why the next two cases in your tutorial letter 102 speak to two of the occurrences where he was alleged to have violated the law and the vote of no confidence did not result in him being removed from office. And those two cases are, very briefly, the case of the midnight reshuffle on the 31st of March 2017, where at the stroke of midnight, President Zuma shuffled his cabinet and removed Pravin Gordhan and Mcebisi Jonas and replaced them with various people that he said represents young, vibrant members of cabinet. But the underlying reason that he did it was because he said there was an intelligence report indicating that Pravin Gordhan was trying to overthrow him. That might be true, but that's why you've seen in the judgment, it's a short judgment too, in your 102, where the court, and interestingly there you'll see it's one judge, Judge Valley, one individual judge who now seemingly has more power than all 400 members of parliament who've put Jacob Zuma in power, where he said, "You as president, you most certainly do have the right to shuffle your cabinet. The Constitution allows it. And you'll notice that the Constitution doesn't specifically state any conditions or requirements. But absolutely, if the rule of law means anything in this country, it means that if you appointed those persons because you thought they were the best for the position, when you remove them, you should also be able to justify it based on the principle of legality, which means, does it appear to be in conformity with the law? And how you assess that is there a rational connection between what you've done and the information which you've relied on to reach that objective? And that's all the court said, and that's why it's not a counter-majoritarian dilemma. All the court said is, give us the document, the record that you relied on, and your reasons. That's all we want from you. Because only once we have that can anyone then challenge what you've done and say, look, this report really is scandalous, it doesn't have any sway. So the court knew the limit of its power. And of course, we know that Jacob Zuma never has produced that record, but time has gone by, it's no longer really a burning issue. Did you have a question?
In support of your answer, you would certainly come across a question that says, support your case. When you say your family versus the nation, the textbook says the public consensus.
Yes, not by, yes.
But now, the whole thing said, the remedy is by the position of the court. So now, that penalized the like court actually what the judge said.
No, that's exactly what we're looking for, and that's why, unfortunately, constitutional law is such a dynamic subject. It changes daily. Very much. That's why you need to know these new cases. And luckily for you, most of the new cases are well publicized, and they're in, we're discussing them, and they're in the news, and that's why I've given you at the end of each my little commentary that makes it become clearer to you what the relevance is. But we're looking for the most recent precedent. That's the whole process of the legal system in South Africa is stare decisis. You look for the binding precedent. And the textbook was produced in 2014. It's way out of date. So unfortunately, it says that, because at the time, that was the truth. It's no longer the truth. And so we're looking for the best possible case to support your answer, the most recent, the most authoritative. And so very quickly, the other case where it was clear that there was a lot of political interference in the effective functioning of the state is the case of the DA versus the Minister of International Relations and Cooperation in your book. Yes, it's al-Bashir. And fortunately, we also now can look back in retrospect and see that al-Bashir has been overthrown by the people of Sudan. So maybe there was some merit in the original arrest warrants, and therefore it again proves that when President Zuma was protecting al-Bashir by letting him leave the state, even though the court had said he cannot leave the state until he's been arrested, he was aiding and abetting a war criminal. And I just to make it clear to you, when I say Jacob Zuma helped him, the Constitution itself tells you in Section 84 that the President is head of the executive, but more importantly, he head of state, and as head of state, it says, for example, he is responsible for receiving foreign dignitaries like foreign presidents. Likewise, when they leave the country, he also should know Omar al-Bashir is about to leave, and he was the one who gave that instruction. Get Omar al-Bashir's aeroplane from OR Tambo Airport to Waterkloof Airport so that he doesn't have to follow all those strict procedures because he's going to be arrested there. Get him to Waterkloof from Sandton because he was having the African Union meeting. Get him to the Waterkloof Air Force Base. Let him fly out, and we'll tell our lawyer who's arguing in court that we'll keep him here until because the court has already said he cannot leave the country. Do you realize that's a contemptuous violation of the court, of the rule of law, of the Constitution? Yes, how his very role as head of state is to secure the integrity of all the international obligations that we voluntarily and in good faith undertaken, and we had been so serious about the Rome Statute that we'd not only ratified the Rome Statute, but we had made our own domestic law which would implement it, called the Implementation of the Rome Statute of the International Criminal Court Act, which says in Section 7, we shall arrest any person who is wanted by the International Criminal Court and keep him in our country and either try him here or extradite him to the International Criminal Court. President Zuma was well aware of our obligations, and yet he obstructed the courts. He willfully disregarded the law, and the result then, that's what the case of DA versus Minister of International Relations, the result is that then there was this political pressure for South Africa to then withdraw from the International Criminal Court and argue, we don't see it as legitimate, it's imposing obligations on us that make us uncomfortable because we are committed to the solidarity with the Sudanese people, and we're engaging in peace talks with trying to mediate peace talks with the Sudanese. So we couldn't comply with the obligation to arrest Omar al-Bashir. So those cases that are in your 102 really all do show the serious violations of the rule of law, unfortunately with Jacob Zuma as the common denominator, but they have radically informed us about how this constitution is actually supposed to be understood and interpreted. And now moving forward, processes are now put in place to make the National Assembly more effective. Because if you had to answer, has it been effective so far in holding the executive accountable? You can't easily say yes. There are all these examples. The UDN case then, we haven't discussed that, but that really is the offshoot again of all of these votes of no confidence, where the UDM said, we now have to have a vote of no confidence in this parliament against Jacob Zuma because we know that he was involved in allowing or enabling Omar al-Bashir to leave the country. And that's when they said, we know that it's a sensitive issue. We want the court to order that the speaker, the colonized speaker, because we know that she was very much protecting Jacob Zuma, so they said we want the court to make an order that she must declare that this vote take place in secret. And remember, the court respects the integrity of its role and the role of the other two branches of state. So the court didn't say to the speaker, you must make it a secret ballot. All they said to her is, the Constitution allows you to exercise your discretion on how best to make the processes work more effectively in Parliament. Therefore, you have the right to declare whether or not you think it should be a secret ballot. And then we saw that the Speaker did say it shall be a secret ballot. So it's not many cases that are the newest ones, but these few cases have really clarified for us the role of the public protector and the status, the role of the National Assembly, what they can do, and very importantly, that the executive must be accountable, and if the president isn't complying with the law, he must be removed. And I think that's now going forward, Cyril Ramaphosa as the next president, or likely to be, and let's just talk about the past, up until tomorrow's election. As president, he's been fully aware that he's got to be accountable and open and responsive. That's the kind of threat you need hanging over the executive. And that's why we have elections every 5 years, so that they know that they can be voted out of office if we as the people have lost confidence in their ability to function in terms of the Constitution and to make sure that the state operates optimally. Because corruption hurts the poorest of the poor. That money that should go to housing, healthcare, education is being siphoned off into the pockets of the elite. And that's, I think, let me try and make this the last few more points. I know we're taking a long time. That's why I emphasize Ubuntu. And you probably think, well, this has got absolutely no relevance. But I just want you to think about how you could decolonize constitutional law. And so you're decolonizing constitutional law by reverting to typically African customs and traditions that resonate with how we should interact with each other on an ethical level. What is the minimum we expect from other people? is that they don't lie to us, they don't steal from us, they don't cheat us. We expect that from the president too. We expect that from our ministers. That's what Ubuntu is that we all working together for a common purpose, because we know that in a context of scarce resources, Ubuntu means that everyone's vote counts, everyone's opinion counts, everyone is of the same worth and value, and therefore, like in Merifong, you can't just say to the people, stuff you, go to Northwest, we don't care. You have to actually value their input. And when they say we don't want to go to the Northwest, and they've got legitimate reasons, you must change your perspective, accommodate their perspective. So I've got in the diagram the case of Pillay versus Department of Education. You probably have studied it in fundamental rights, or even if you've never heard of it before. It's definitely referred to in the textbook. It's just a case about, even in a school setting, because what I want you to imagine is, even though we're talking about the state and the legislature, the executive, the judiciary, there are actually very similar institutions operating at other levels. And I'm not talking about in government, but even in a university, we have a student parliament. It's fulfilling the role similar to our National Assembly, in that they, the democratically elected representatives of the students, speak for the students. They go to the Vice Chancellor and they say, we don't like the exam timetable, or we think this needs to be changed. It's a democratic process. We also have at the university a ombud. Ombud is another name for a public protector. So all of these systems work. And that's why they are replicated in other institutions. And at a school where Pillay, Miss Pillay, can't remember her first name now, turned 16, and as a Tamil, South Indian, South African of Indian descent, it was a cultural and traditional component of her upbringing that at the age of 16, to prove that she's now becoming a woman, her grandmother would buy her a diamond nose stud. And that would represent, and this is what I'm conveyed in the personal as political, you need to identify the culture you're living in and your identity as a human being, your dignity. And if your dignity as a human being depends on the color of your skin, and therefore you want to see a street name that says Nelson Mandela, that's what you're entitled to. But in Pillay's case, the school said, it's jewelry, you're not allowed to wear it. And the Constitutional Court came to the conclusion, they said, the school can't just impose this rule without accommodating the identity and culture and dignity of this person. So what's now known as reasonable accommodation must take place. And that's really what's happening, is we need systems that accommodate the views of everyone. That's what democracy is. And that can ensure that everyone actually benefits in society. And that brings me to what I've included on the diagram. I hardly mention the local sphere, but that's because everything that happens at the local sphere is actually just exactly the same as what happens at the national sphere, but just on a much smaller scale. But you must remember, and tomorrow's vote is relevant for this purpose. We are voting tomorrow for national government and provincial government. So you need to know the three fundamental reasons why provinces exist. And it's on your diagram. It's very simply, provinces provide that vital link between the voters, us, and our government. Because we can't all go and sit in Pretoria at the Union buildings telling Cyril Ramaphosa, you must do this and you must do that. So we vote for provincial government to speak for us at the national level. And how do we see that? We know that there's a National Assembly and there's also a National Council of Provinces. That's the representatives of the provinces speaking for us. So that's the first thing, link. Provinces facilitate that important link between us as the voters and our government, because our provinces know about our unique challenges or interests for this discrete geographical area. So Gauteng is the thriving economy. There's not enough houses. What do we need as a priority in Gauteng? More housing, for example. So that's where they'll push that objective of ensuring housing. The second fundamental link between the province and the rest of government, and therefore includes us, is, as we know, the essence of the executive is to implement the law. So it's the province that must implement the national laws. So all the national laws that will deal with things that will affect us at the provincial level, like higher education, even other levels of education, healthcare, housing, social welfare, all of those issues upon which policies have been formulated and laws have been drafted. They can't just say there's a law and this is our policy. They need to be implemented. The province does that. And then very importantly, the province is there to oversee each of the local spheres, making sure that they're doing the right thing and that they're not abusing their powers. And that's why on the far right, near the bottom of your page, is what we term conflict resolution procedures for the fact that we have a multi-sphere system of government. And so you simply need to know, and it was in your assignment question, what happens when there's a conflict when the Constitution says that both the national sphere and the provincial sphere can pass a law on the same issue? That's a concurrent competence. What do you do in that case? Usually, yes, it's Schedule 4, but usually the rule is that the national law will prevail because Section 46 says that if there is already a national law in place that is uniform across all provinces and that regulates service delivery uniformly, and there's nothing wrong with that uniform law, and now a provincial law comes along and is contradictory, there is no way to resolve the conflict other than to declare that provincial law must be done away with and replaced with the existing national law that was already there. But it's slightly more complex then with Schedule 5 issues, which is where it is exclusive provincial competence. So the impression created is that the province can do as it pleases, pass its own laws, no one can say a thing. That's not necessarily true, and you then have to go to Section 147 of the Constitution, and 147 refers you on to Section 44.2. And yes?
So that puts in something here.
Yes. Yes. Well, that's precisely it. Because the liquor bill case liquor is one of those issues where the national government says we certainly don't have to deal with liquor in the provincial sphere. So we are going to derogate our rights and say and give over to the provinces the exclusive right to determine liquor licensing and sale of liquor in the provinces. So you can decide for yourself. In KwaZulu-Natal, you can sell liquor till 9 at night, for example, and on a Sunday. Gauteng might have a different rule. So they said, here it is. You can do as you please. And so the liquor bill was drafted, and then it became apparent that this liquor bill, the liquor bill, directly contradicted an overriding national concern, and therefore the court said, Section 147 is clear that even though the provinces are given exclusive mandates to pass law for themselves, because Section 44.2 can be invoked, the criteria then is you ask yourself, is it absolutely necessary for the national sphere to intervene in order to protect things like national security, the national economy, the essential national standards? Is it necessary to prevent unreasonable action by a province that is prejudicial to another province or to the state as a whole? And does it contradict essential national service delivery standards? Yes, so you need to ask yourself, is it necessary to uphold those very important values of how the state should work best? That there should at all times be minimum standards for service delivery, minimum standards for upholding national security, and for... Yes. So that's why it's a horrible question, but it's in your feedback, and that's what's also now at the end of your tutorial letter 102, is that question about that a municipality. And again, when I say municipality here, remember that the Constitution has Part A and Part B in Schedule 4 and 5. The Part B, even though it talks about the province, the Part B is for the municipality. And that's why refuse removal is dealt with in Part B. And it says the municipality can pretty much regulate its own affairs, but when it comes to something like refuse removal and the municipality says we're not going to remove it once a week, absolutely there's no doubt in your mind that this is going to seriously impede national service delivery minimum standards, but even more so, it is going to have a very prejudicial impact on not only that province, because this refuse that's not being collected is going to cause all kinds of illnesses, but that it's going to then cause pollution, which will infiltrate other provinces and therefore will affect the national unity, the national economy, because everyone's having to go to hospital. So it's not sustainable, and therefore the national law will prevail and will override that law that might have been followed, passed following the right processes and procedures, but ultimately it just is unsustainable, I think is the best word. You can't let it continue to be valid. It has to be declared invalid, and the national law override it. Yes?
I have difficulty in the petrol assurance case, where they had a problem with the rates, whereby I think they were saying that the municipality could not come up with high rates for property, whereas I think from what you just said now, it's something that should be of Schedule 5, when municipalities are dealing with those rates, because of the national government cannot necessarily come and deal with all the property rates of all the municipalities because of different circumstances. Could you kindly please step into that case?
Yes, well, the Fetcher case is relevant for administrative law purposes as well, so you're probably familiar with it there. And of course, for admin law, you're interested in, is it the implementation of an empowering provision? But for constitutional law purposes, the Fetcher case shows us that, and it's very much the same idea as the thinking about when President Jacob Zuma shuffled his cabinet. So the idea is this. Yes, the Constitution does give to the local sphere far-reaching powers to regulate their own affairs and decide how much money they want to accrue through property rates. But at the same time, that municipality must always function on the basis of legality. Is it rational, the decision they're making, that they've now suddenly dramatically increased the property rates that is unaffordable, unsustainable? Is the decision one that is consistent with the rule of law, which says that they can implement a property rate system that functions for the benefit of the municipality, but it needs to be sort of inflation related and a proper decision that can be justified amongst the entire constituency, so the whole municipality. So really it's the essence of, can this decision be seen to be legitimate, rational, reasonable, credible. And if it's not, then it can be overridden because it's contrary to national policies and how governance should take place. The Fetscher case, it was emphasized a lot in the previous study guide, and that's why we've inherited a lot of the discussion on it. But there have been many cases that have now been more decisive in how we approach constitutional issues. That we look at the fund, we don't have to sort of interrogate all the nitty-gritty anymore. We now can simply ask ourselves, is the decision a decision that's taken by a democratically elected body? Yes. But does that decision reflect adherence to the rule of law? And is it compatible with a rational, accountable, responsive government body? And if it is, then obviously there's nothing that the court can do, but otherwise the court is allowed to ask for, tell us why you're doing this, reasons. What is the basis? Because if there's a legitimate reason for the court doing for the municipality, for example, making a certain decision, like an AFRIC forum, then the court can't intrude. So the essence is the decision a legitimate, lawful, acceptable decision in terms of those fundamental concepts of constitutionalism, rule of law, democracy, separation of powers. That's why those concepts are vital to your understanding of the entire constitutional system and how it is supposed to operate at the three distinct spheres. So there's not much more I need to say, and it is now 4. I don't know if there is anything else anyone wants to say. I can't think of anything else to say. Yes, there's one question at the back. Hold on. Sorry, yeah, I can get your just. Yes, carry on. Oh, yeah. Yes, the question is simply, why do I use the word colonized instead of captured? It's only because I want to provoke you. Because saying something's captured, you might not really understand the full impact. Whereas if you think about it in terms of South Africa's history of colonization, you'll realize colonization is not something that has any good characteristics. So it's a bad thing. That's why I use colonization when, in fact, Sujit Chowdhury uses capture. He uses capture and colonization. So really, I just say it to make you realize how serious state capture is. Yes. All right, I don't know if it's recorded, but I'll record it on Thursday, and I think there's not much more I can say. Thanks, yes.
Thank you very much.
I think I must be your